Welcome to the fourth African Law Seminar on Democracy and Good Governance in Africa. The first lecture on the African Charter on Democracy, Elections, and Governance will be given by Ben Kioko, the former Vice President of the African Court on Human and People's Rights and the longest-serving AU Legal Counsel. He was involved in the legal drafting and political negotiations that led to this historic agreement. Ben, my dear friend, it is my pleasure to introduce you and to give you the floor.
Thank you very much, Virginia. It's always a pleasure to see you. You and I go back a very long way. When we started this process of legal training for Africa. At that time, you were the United Nations, and we had just signed an agreement between the Office of the AU Legal Counsel and the UN Office of, the UN Legal Council and Undersecretary General for Legal Affairs. And that led to those seminars, and really I'm very happy to see you again. Virginia is assisted by Candice. Thank you, Candice, for the good work you are doing behind the scenes. My very good friend and current legal counsel, Professor Aja Godish, is also with us. And I think it will be it's very good that she's here, because there will be an opportunity for her to maybe take the floor and throw light to some of the issues that I may not have covered. So a very warm welcome to Professor Godish. Now, my lecture is entitled The African Charter on Democracy, Elections, and Governance, in short, ACDEC, a framework for good governance in Africa. And I want to start by giving an African proverb, which is to the effect that when your neighbor's house is on fire, extinguish it with your water. When your neighbor's house is on fire, extinguish it with your water. And there's another variation to that proverb, which is that when your neighbor's house is on fire, spray or sprinkle yours. And that is because that fire in your neighbor's house is likely, or poses a risk that it is likely to cross to your own house. And this is what ACDEC is all about. It is like a comprehensive set of rules by a neighborhood association or a body corporate for a gated community. And within a neighborhood association, you'll find rules like you are not allowed to burn grass or shrubs in the compound. Instead, you should cut them, or do not disturb your neighbors, etc., etc. So ACDEC is like the neighborhood association set of rules, except the neighbors are African states and the citizens. And there's a clear reasoning for this. By nature, governments believe in the maxim that if you live in a glass house, do not throw stones. So states want to see no evil, do no evil, hear no evil. That is the way states operate. So there's need for rules to ensure that states play by those rules, because if they do not and there's a conflict and forced displacement, the citizens will seek refuge in a neighboring country. So ACDEC is the continental standard for democratic governance and accountability, and is the principal normative instrument of the African governance architecture. It is arguably the most important and comprehensive instrument in giving practical effect to the principle of non-indifference that you find in Article 4H, J, M, and O of the Constitutive Act. Now, the shift towards non-indifference has many milestones, but in my view, the most significant are the adoption of the 1981 African Human Rights Charter, the famous 1990 Declaration on Fundamental Changes taking place in the world and their implications for Africa, the Constitutive Act in 2000, and ACDEC in 2007, this charter in 2007. This instrument is anchored in the Constitutive Act, and it's not just a legal commitment, but a vision for governance aimed at ensuring peace, stability, and sustainable socioeconomic development across Africa through peaceful, credible elections, limiting presidential term extensions, protecting human rights, promoting good governance, and participatory democracy. It obligates state parties to hold credible, transparent elections and to establish independent electoral management bodies. These are some of the requirements in ACDEC. Now, there were many other soft law instruments before ACDEC, including the 2002 Declaration on the Principles Governing Democratic Elections in Africa, which ACDEC incorporates. This declaration had noted that conflicts on the continent are caused or exacerbated by many factors, notably lack of democratic practices in the management of public affairs, non-observers of human rights, as well as unfair electoral processes. In my presentation, I argue that ACDEC is therefore critical in the context of contemporary African governance. Now, the structure of my presentation is as follows. Chapter 1 is on current state context. In other words, what is the current state and context on the continent when we are meeting here to discuss ACDEC? Number 2, the status of ratification, accession, and reservations to ACDEC. Number 3 will be unique attributes of ACDEC, because there are some unique features of ACDEC that you don't find in any other instrument. Number 4 will be an overview of the provisions in ACDEC and some gaps that I will highlight. And then number 5 will be to contextualize or look at the issues and concerns in the negotiation process for this instrument. Number 6 will be justiciability of ACDEC as a human rights instrument. And that is because the African Court on Human and People's Rights, in a previous judgment that I'll be referring to, or previous judgments that I'll refer to, has declared ACDEC as a human rights instrument. And then now, after that, I'll make a conclusion. I'll look at the challenges and future prospects for ACDEC. Now, before I dive into the next section of my presentation, let me remind all of you that this week, my friends, sisters, and brothers will be making presentations that are interlinked to ACDEC. I will therefore not dwell much on the issues that they will be focusing on. Now, tomorrow, my sister Abibata Mbari of AU Commission will be talking about democratic elections in Africa. And elections is a key element of ACDEC, and therefore I will only speak about elections to the extent that I feel it's important for me to speak to it at this stage. Otherwise, there will be a standalone presentation on elections tomorrow. On day after tomorrow, Dr. Johnny Kubaji Bodi of AUC will be speaking on preventing and combating corruption. And this is linked with ACDEC because, as the Anti-Corruption Convention itself acknowledges, corruption undermines accountability and transparency in the management of public affairs. On Thursday, I think it will be Batlokwa Makong, Chief of Staff at APRIM, who will speak about the APRIM. And again, this is relevant because APRIM implements this instrument. Finally, on Thursday, my brother and friend, Judge Abdugawi Yusuf, will be speaking on another major component of ACDEC, which is unconstitutional change of government. Now, let's move to the current context or state on the continent. Now, we are discussing this instrument at a time when some observers suggest that democracy in Africa is on its deathbed. There seems to be a crisis of confidence in our leaders. One such observer is George Okoth Obo, a well-known African journalist of Ugandan origin. In a piece published a few days ago entitled "The ABCs of Vote Rigging for Africans," he noted that democracy is not in good health. Across Africa, it is in its worst condition in a generation. He goes on to note that the standards of vote rigging in Africa were once world class, but have fallen so spectacularly that the craft is now comedy. I want you to think that again, that democracy in Africa is in its worst condition in a generation, and that the standards of vote rigging in Africa were once world class, but have fallen so spectacularly that the craft is now comedy. I would like to identify a number of key indicators with regard to the state in which we are. And I think it shows that democracy is on retreat. We are witnessing democratic retrogression or democratic recession, depending on what you prefer. The first indicator is there is an upsurge in popular uprisings. We are seeing an upsurge in popular uprisings like the one in North Africa during the Arab Spring, during the period 2011 to 2021, which is known as the decade of popular uprisings. Why is there a rise in uprisings recently? This points to factors such as youth disenfranchisement, economic challenges, political exclusion, corruption, and lack of accountability. Number two is electoral integrity crisis. Evidently, there is a crisis in the management of elections in Africa. We are seeing blatant manipulation of elections, including voter fraud, intimidation, and exclusion of the main opposition candidates, or preventing them from campaigning freely. We saw this trend of disqualifying main opponents in recent elections in Cameroon, Cote d'Ivoire, Tanzania, Guinea-Bissau, etc. This no doubt impacts public trust and democratic legitimacy. Election results in many places are at best suspicious. We are now seeing the truth in the words of Soviet Union dictator Joseph Stalin, who stated, "Those who vote decide nothing. Those who count the vote decide everything." We are seeing the truth in those words today by Joseph Stalin. The third indicator is manipulation of presidential term limits. There is a growing trend of leaders amending constitutions to extend terms of office. This mechanism was used by some post-independence leaders, but now is on the rise with recent cases in Uganda, Burundi, Rwanda, and Togo. Between 2002 and 2023, constitutional amendment aimed at elongating the tenure of incumbent leaders took place in 25 African countries. Between 2002 and 2025, we had amendments in 25 countries. That is 45% of all AU member states. And 20 of those amendment processes were successful against only 5 failures. That is a huge number in a period of about 20 years. Interestingly, most of these constitutional amendments took place after adoption of ACDEC in 2007. There were 15 such amendments, starting with Cameroon, removing presidential term limits in 2008, to the recent one in Togo in 2025. The fourth indicator is resurgence of coup d'etat. There's been a recent rise in military coups across the continent, including in Guinea, Niger, Gabon, Mali, Sudan, Burkina Faso, Madagascar, and Guinea-Bissau a few days ago. Often, these coups are caused by the failure of democratic institutions, public discontent, political exclusion, and economic mismanagement. Since 2008, there were 22 coups from Mauritania in 2008 to Madagascar in October 2025 and Guinea-Bissau a few days ago. At the same time, several countries reported attempted coups or failed plots during the period 2023 to 2024. This indicates continued instability, and what is called the coup belt trend in parts of West and Central Africa is actually expanding. The fifth factor is resurgence of armed conflict. We are seeing more and more armed conflict on the continent, with no region of the continent spared. During the 50th anniversary of the OAU in Addis Ababa on May 25th, 2013, the AU summit adopted a solemn declaration to end all wars by 2020, where member states pledged to rid the continent of wars, civil conflicts, human rights violations, and violent conflicts by 2020. This is an African Union flagship project, which is called AU Flagship Project of Silencing the Guns by 2020. However, this deadline of 2020 was extended to 2030, but even now it seems unachievable. We're talking about 5 years to get rid in the continent of war, civil conflicts, human rights violations, and violent conflicts. The next factor or indicator is democratic retrogression and human rights violations. There's a broader trend of democratic backsliding, where authoritarianism is on the rise and human rights violations, particularly of the right to life, have worsened. The last factor is the role of leadership in Africa's democratic crisis. Democratic institutions in Africa tend to be weak. By and large, the institutions of power are concentrated in the hands of one man or woman. It follows that bad leadership is the core problem. It is bad leadership that is the fundamental cause of Africa's democratic crisis. In these circumstances, it would be appropriate to ask the question, what is wrong with our beloved continent? What is the problem with Africa? I have an answer for you from a very unlikely source. In a book entitled, What is the Problem with Africa?, published by Longman in 1986, President Yoweri Museveni answered this question by highlighting the importance of leaders respecting constitutional term limits and the dangers of leaders who alter rules to stay in power. He stated, "The problem of Africa in general and Uganda in particular is not the people but leaders who want to overstay in power." He went on, "No African head of state should stay in power longer than 10 years. That was 1986. And the person who has given us that advice is still in power. Now, personally, I'm in full agreement that bad leadership is the cause of Africa's democratic crisis. Barack Obama also addressed this issue of manipulation of term limits in an address at Mandela Hall during a visit to the AU headquarters on 28 July 2015. In an address to the people of Africa, he cited Nelson Mandela and George Washington as examples of leaders who made lasting legacies by stepping down. He urged leaders to respect constitutional term limits, stating that a leader who needs to alter rules to stay in power has failed to truly build the nation. He added, when a leader tries to change the rules in the middle of the game just to stay in office, it risks instability and strife, as we have seen in Burundi, and is often just a first step down a perilous path. But if a leader thinks they are the only person who can hold their nation together, if that is true, then that leader has failed to truly build their country. A friend recently argued that the current crop of leaders is probably the worst in the history of the continent. I agree, but I'm confident that the youth will put things right. I now move to another section of my presentation, the fourth one, which is the status of ratification and implementation of ACTEC. Before I do so, I would like to draw attention to an important instrument adopted by ECOWAS in December 2001, and all the 15 states of ECOWAS are parties. This is the ECOWAS Protocol on Democracy and Good Governance. The title is very long. It talks about being supplementary to the protocol relating to the mechanism for conflict prevention. So I just call it the ECOWAS Democratic Protocol. There's also another one within SADC, but the one of ECOWAS is important because it's been the subject of a decision by the African Court. Now, ACTEC was adopted on 30th January 2007 and came to force almost exactly 5 years later on 15th February 2012, when Cameroon deposited the 15th instrument of ratification. Where are we with the ratification? On the status of ACTEC, as of this morning, there are 46 signatures and 39 ratification out of 53 AU member states. On the regional distribution of ratifications, there's a higher concentration in the West African region with 15 states out of 15 countries. So all of them have ratified ACTEC. It is followed by Eastern Africa with 9 out of 13 countries. Then Southern Africa with 8 states out of 11. Central Africa with 4 out of 9. And then finally, Northern region with 3 out of 7 states. Among the countries that have not ratified are the following: Botswana, Burundi, Congo, Democratic Republic of Congo, Egypt, Eritrea, Eswatini, Gabon, Libya, Mauritius, Morocco, Senegal, Somalia, Tanzania, Tunisia, Uganda. And when I look at the list of the countries that are not parties, I ask myself, why Botswana? Why has Botswana not ratified ACTEC or become a party to ACTEC? What about Mauritius? These are countries that I think are already implementing many of the, if not all the provisions of ACTEC with regard to democratic governance. What about Senegal? What about Tanzania, until now, one of the most peaceful countries in Africa? In the case of Botswana, Mauritius, Senegal, I don't know. But in the case of Tanzania, I think it could be that it's because there is a constitutional provision in the 1977 Constitution of United Republic of Tanzania as amended, which sets up specialized electoral courts and allows electoral disputes to go to that court, all disputes relating to elections except presidential elections, meaning that presidential elections cannot be challenged in any court of law. I don't know whether that is the reason or there's another reason. Now, regrettably, in treaty negotiations, my colleague Professor Aja will confirm that in negotiations, you see some states robustly taking part in the debate, and they succeed in lowering the standards, but we know very well that they will never be party to the instrument in question, but they have succeeded in lowering the standards for others, which is really quite regrettable. Now, in any of these treaties, including ACTEC, many of them rather, states may enter reservation. Article 51(2) of ACTEC allows reservations, but in terms of the Vienna Convention or the law of treaties, such a reservation should not be incompatible with the object and purpose of the treaty. So that is a rider. You can enter a reservation, but it should not be incompatible with the object and purpose of the treaty. Now, out of the 39 states that are parties to ACDEC, Equatorial Guinea is the only state that has entered reservations on some articles. I will only highlight 3 of them. The first reservation is with regard to Article 7, which requires states to take all necessary measures to strengthen the organs of the Union that are mandated to promote and protect human rights and to fight impunity and endow them with the necessary resources. Now, Equatorial Guinea basically said Equatorial Guinea has organs that watch over the above principles. It is therefore the Union that must strengthen these national organs, providing them with the economic means necessary for their normal functioning. Moreover, with the annual contribution of Equatorial Guinea to the Union's budget, it does not need to allocate additional or extraordinary resources to it. In other words, Equatorial Guinea is saying, if you want to implement this, give us the resources. We are not going to allocate additional ones beyond what we pay to the Union. On Article 14.1, which obligates state parties to strengthen and institutionalize constitutional civilian control over the armed and security forces to ensure the consolidation of democracy and constitutional order, the Republic of Equatorial Guinea says, we understand this requirement does not conform to the reality of the national juridical order as provided in this and this article of the Basic Law. In other words, they are saying we cannot implement this particular provision. The last reservation that I want to highlight relates to Articles 18, 19, 20, 21, and 22 of ACTEC, which allows states to request the AU Commission for assistance, advisory services, or assistance from the Democracy and Electoral Assistance Fund or the Democracy and Electoral Assistance Unit. These articles also address how electoral observer missions will be organized. Equatorial Guinea basically says, and I paraphrase, Equatorial Guinea considers that the state is sovereign and is the government by virtue of national law which must decide when and under what circumstances the elections are to be called and whether or not to invite observation missions before and during the elections. So basically they are saying we don't agree. It's for us to decide whether we want to invite you as an observer or not. Now, as I move now to the unique attributes of ACTEC, I have asked Virginia and Candice to share some open access articles in volume 63 of special supplementary issue, which was done by SOAS University in London in collaboration with Cambridge University Press in 2019. These ones are accessible because they are open access articles. And you'll find the article that explains the origin of ACDEC, the past, present, and future. Then you have an article which looks at how the court arrived, what is a human rights instrument, basically. And then you have an article which I published on justiciability of the African Charter. Now, unique attributes of ACDEC. Compared to other AU instruments, the ACDEC has at least 7 unique provisions on governance and democracy, as well as sustainable development. The first attribute is ACDEC is the first AU instrument that integrates all the AU mechanisms in its implementation, such as the AU Commission, Pan-African Parliament, the Court, the Security Council, Committee on the Rights of the Child, ECOSOC, etc., and also regional economic communities. Is the first instrument that incorporates all this in its implementation. Second, ACDEC has its own sanctions provisions additional to those in Articles 23, 2, and 30 of the Constitutive Act. Article 46 of ACDEC empowers the Assembly and the Peace and Security Council to determine the appropriate measures to be imposed on a state in breach of the ACDEC. So if a state is in breach of this instrument, the Peace and Security Council and the Assembly are empowered to decide what measures to impose. However, both sanctions regimes, the one in ACTEC, the one in the Constitutive Act, lack clear guidelines or procedures for enforcement beyond breaches for unconstitutional change of government. So there are clear guidelines on how unconstitutional change of government will be imposed, but not for the others. And I think the one issue that you realize at the end of this discussion is that in terms of the norms, in terms of the values, as a continent, we have done extremely well. Our biggest problem is implementation. We adopt the norms, we don't implement them. Now, the third unique attribute of ACDEC is that it's the most significant instrument on elections, in that it has 16 provisions related to elections. And I think my colleague, Agbata Bari, will be dealing with that tomorrow on how they implement those provisions of ACDEC. The fourth attribute is that it's the only instrument that gives a legal basis in Article 37 to the concepts of sustainable development and human security through the NEPAD objectives and the UN Millennium Development Goals. However, in my view, this needs further enrichment through practice to reflect the current evidence of climate-fueled conflicts, e.g. in the Sahel. It should also take account of the recent advisory opinion by the International Court of Justice on climate change, which was issued in July 2025. The opinion affirmed that inaction on climate change can be considered an internationally wrongful act with potential legal consequences and requires states to prevent significant harm and cooperate internationally. Now, this opinion, if I may digress a bit, was requested by the UN General Assembly, initiated by Vanuatu and supported largely by the Global South. And the International Court of Justice was clear that these obligations arise under both climate change treaties and other sources of international law, including environmental treaties, human rights treaties, and customary international law. Now, the fifth attribute is that ACDEC is the first AU instrument that seeks to address the challenges faced by ethnic minorities, migrants, marginalized, and vulnerable social groups. Article 8.2 of ACDEC obligates state parties to guarantee the rights of women, ethnic minorities, migrants, people with disabilities, refugees and displaced persons, and other marginalized and vulnerable social groups. The sixth attribute is on participation in the governance process by groups with special needs. State parties have undertaken, pursuant to Article 31 of ACDEC, to promote participation of social groups with special needs, including the youth and people with disabilities, in the governing process. They are also obligated to ensure systematic and comprehensive civic education to encourage their full participation in democracy and development processes. The seventh and last unique attribute is that in terms of Article 25.5 of the ACDEC, perpetrators of unconstitutional change of government may also be tried before the competent court of the Union. This provision is the reason or the basis for the insertion of this crime in the Malabo Protocol, the International Crimes Protocol for the Merged Court of Justice and Human Rights, adopted in Malabo, Equatorial Guinea on 27 June 2014. Now, I move to another section on overview of ACDEC provisions. What I did now was to focus on the unique ones. Now I'm giving an overview of the ACDEC provisions. I'll first focus on the structure and legal framework of ACDEC, the provisions relating to structure and legal framework. Now, ACDEC consists of 53 articles in 11 chapters, with 3 operational chapters and 8 substantive chapters that deal with different aspects of governance, including elections, human rights, and rule of law. Second, it's not a new instrument as such. Rather, it is a consolidating instrument into a legally binding instrument of commitments already taken by member states in previous soft law instruments, many of which are already being implemented. The ACDEC process started in 2003 when the Executive Council of the AU endorsed an AU Commission recommendation to do so. I'll allude to this later on. Third, ACDEC was preceded by 18 soft law instruments and frameworks, including NEPAD and APRIM, touching on constitutionalism, democracy, good governance, human rights, justice, the fight against impunity, etc. Subsequently, it was followed by another 7 instruments, making a total of 25 instruments. Now, the previous instruments, I don't need to go through them all, but I did allude earlier to the 1990 Declaration, which was a seminal instrument, the Cairo Agenda for Action, 1995, OJA's Declaration of Unconstitutional Changes, 1999, Government Declaration 2000, the Solomon Declaration on the Conference on Security, Stability, Development, and Cooperation in Africa, 2001, together with a Memorandum of Understanding for the CSSDCA in 2002, and so on and so on and so on, including the protocol relating to the Peace and Security Council of the AU. Now, ACDEC reflects the shared values, standards, and norms of the AU and its member states. It envisages states holding each other accountable to ensure compliance and avoid application of the sanctions provided for in Article 23 of the Constitutive Acts against states that fail to comply with the principles and policies of the Union. There is also mention in the Constitutive Act in Article 4M, respect for democratic principles, human rights, the rule of law, and good governance. And in terms of the African Agenda 2063, Aspiration 3 talks of an Africa of good governance, democracy, respect for human rights, justice, and the rule of law. Now, on governance and democracy, that will be broken down into a number of sections, but let me start with elections and electoral integrity. As I already mentioned, there are 16 provisions relating to elections. In Article 17, states have committed themselves to holding regular, transparent, free, and fair elections. Regular, transparent, free, and fair elections. Those words are not just words, they are commitments by states. But what we are seeing today does not seem to conform to those 4 factors: regular, transparent, free, and fair. The states in Article 17 have also committed to establishing and strengthening independent and impartial national electoral bodies, and also to establish and strengthen national mechanisms that redress election-related disputes in a timely manner, and also to ensure fair and equitable access by contesting parties and candidates to state-controlled media during elections. In other words, access to state-controlled media should be fair and equitable and accessible by all contesting parties and candidates. And finally, to put in place a binding code of conduct governing political stakeholders, government, and other political actors prior, during, and after the elections. On the electoral management bodies, the ECOWAS democracy protocol is more elaborate in Article 3. And this is significant because later on, when I deal with the justiciability, I will demonstrate that this, in fact, formed the basis of a decision of the court. Article 3 of the ECOWAS democracy protocol states the bodies responsible for organizing the election shall be independent and or neutral and shall have the confidence of all the political actors. Where necessary, appropriate national consultation shall be organized to determine the nature and the structure of the bodies. Furthermore, on changes to the electoral law, the ECOWAS Democracy Protocol has a unique and more specific provision in Section 2, Paragraph 1, which provides no substantial modification shall be made in the electoral laws in the last 6 months before the elections. So in other words, if you want to change your electoral law, it should not be done in the last 6 months before the elections, except with the consent of a majority of political actors. So as I indicated, the court has used this provision, and I will demonstrate that later. Now, with regard to transfer of power and constitutional integrity, ACTEC emphasizes the importance of constitutional order and peaceful transfer of power, Article 5. There is also an elaborate provision against unconstitutional changes of government, including amendments that undermine democratic principles, Article 23. On amendments to the Constitution, ACTEC requires that the process of amendment or revision of the Constitution repose on national consensus obtained, if need be, through a referendum. Now, on human rights and social inclusion, ACDEC has provisions on the rights of women. It commits states to promoting the role of women in governance and obligates states to create the necessary conditions for full and active participation of women in the decision-making processes and structures at all levels, and also to encourage the full and active participation of women in the electoral process and ensure gender parity in representation at all levels, including legislatures. Now, on special needs groups, it provides that Article 31 also has a provision on youth, people with disabilities, and marginalized groups in governance processes. On protection of fundamental freedoms, ACTEC guarantees freedom of expression, participation, equality before the law, and freedom from discrimination in Article 13, 8, and 10. There are also other rights which are specifically provided for in ACTEC. And these rights which are provided in ACTEC correspond with similar rights in the African Human Rights Charter. Key among them is the right to participate, which is more elaborated in ACTEC than in the Human Rights Charter. So you have the right to participate in Article 13, right to freedom from discrimination, Article 8, equality before the law and equal protection of the law, Article 10, 3, freedom of expression, Article 27, right to education, Article 43, a satisfactory environment, Article 42, peace and security, the right to peace and security, Article 38. Later on, I'll show which of these rights have been litigated before the African Court. On good economic and corporate governance, ACTEC has provisions on public debt management, natural resource allocation, and anti-corruption measures, Article 33. It underlines the importance of transparency, accountability, and private sector development. It also contains undertakings by states on many aspects of political, democratic, economic, social, and corporate governance. And the Chapter 9, Article 27 to 43 deals with these aspects. On constitutional bodies, because these are very important at the national level, independent constitutional bodies. ACDEC Article 15 requires states to establish public institutions that promote and support democracy and constitutional order, and whose independence or autonomy is guaranteed by the Constitution, and with resources to perform their assigned missions efficiently and effectively. There's also a provision in Article 2.5 and 32.3 on the independence of the judiciary. Now, civil society, there's a provision on, or there are provisions on the role of civil society in Article 12 and 29. And it requires states to create conducive conditions for civil society organizations to exist and operate within the law, and to ensure and promote strong partnerships and dialogue between government, civil society, and private sector. on sustainability and development. Architect aligned with the NEPAD and the Millennium Development Goals by requiring state parties to pursue sustainable development and human security. Now, one then could ask, all these provisions, how are they going to be implemented? There is a chapter on implementation and accountability. On reporting and accountability, Architect borrows from human rights treaties to provide for reporting by states on the measures they have taken to implement Architect. And they are required to submit a report every 2 years, Article 49. However, there's been a very, very low compliance rate. To date, only 2 states, Togo and Rwanda, have submitted reports. And I think this is an area that requires thinking about how to encourage states to file their reports with the AU Commission. Because those reports allow the AU Commission, in consultation with relevant organs, to make what is called concluding observations. And those observations will tell a state that you haven't done enough or you have done enough. But if states are not filing the reports, then you can't be able to do that. Now, there's also a clear role given to the AU Commission in promoting architect and implementation, developing normative frameworks, etc., and providing guidance and assisting states to implement Article 44. So the AU Commission is the central coordinating structure for the implementation of Architect and in coordinating evaluation, in coordination with other organs of the Union. Finally, on enforcement of Architect, Architect can be enforced at the national level if a state has domesticated Architect by an enabling legislation. It can also be enforced at the African Court on Human Rights to hold states accountable for violation of Architect, but only after exhausting domestic remedies. To access the African Court, an applicant must have exhausted all domestic remedies before they can come to the court. It's not an appellate court, but it's a requirement that you must have exhausted all domestic remedies. Now, I now move to another aspect, which is the gaps in Architect. The first gap, and I see about 5 gaps. Architect does not make a link between terrorism and governance, even though terrorism is to some extent caused and or aggravated by democratic deficits, marginalization, bad governance, and electoral malpractices that Architect seeks to address. Now, this issue was not raised in the original drafts or by delegates, but I think it is probably adequately addressed in the 1999 AU Convention on Preventing and Combating Terrorism, which entered into force in 2002 December. So perhaps that's why it was not included here in Architect. Now, there's need to define, number 2, there's need to define or develop clear practice on what is made by a culture of democracy in Articles 11, 12, and 29. Because this is a lot of objectives, but I think there's need to be able to at least say in practice how this loft objective will be achieved. Because, for example, in respect of another issue, it talks about another issue in Article 12.4. States are supposed to undertake civic education, national educational curricula, and development of appropriate programs and activities. So if the culture of democracy is to be achieved through education and so on, then perhaps this should have been clearly stated. And maybe there's need to then follow it up through practice and see how this culture of democracy can be developed. Is it through schools, at what level, et cetera, et cetera? The third gap is that Article 37 of ACDES gives a legal basis to the concepts of sustainable development. However, this needs further enrichment through practice to reflect other factors, such as the current evidence of climate-fueled conflicts, e.g. in the Sahel, as I mentioned earlier, and also take into account the advisory opinion of the ICJ on climate change. The fourth gap is that ACTEC encourages the development and utilization of ICT. However, it does not address cyber governance or the role of digital technologies in governance, online safety, freedom of digital expression, and cybersecurity. There was a subsequent AU Convention on Cybersecurity and Personal Data Protection of 27 June 2014. These instruments somewhat has addressed this gap, and I say somewhat. The fifth gap relates to what I mentioned earlier about popular uprisings, because these gaps impact the ability of the AU and PSC to make a principled and consistent response to events similar to the North African uprisings. And I'm saying this because the events in Tunisia, Egypt, and Libya expose the gaps in ACDEC. Now, Abbas Lamtane Lamamra, in a keynote address to the open session of the Peace and Security Council held in Addis Ababa, Ethiopia on 11 July 2011, he noted, the uprisings in North Africa exposed a dangerous vacuum in the arsenal of AU instruments that needs to be urgently filled by putting in place appropriate response mechanism that will enable the continental body to timely respond to such phenomena with the required robustness and effectiveness. So there's a gap, and that gap does not allow the AU to take a principled and consistent response to events similar to this. The next gap, and the final one, is that the relatively comprehensive framework for enforcing the norm on unconstitutional change of government has not provided for similar mechanisms for sanctioning serious democratic and human rights abuses, even when they are the cause for the unconstitutional change of government. So you find there's an unconstitutional change of government, but that was caused clearly by serious democratic and human rights abuses. So how do you deal with that? And perhaps this is why the debate on whether there's a good coup or not remains unsettled. And the African Union Peace and Security Council has been criticized in some cases where an unconstitutional change of government took place, but the Peace and Security Council did not characterize such change as unconstitutional change of government. Now, let me focus now on some of the issues that arose in the negotiation process, but briefly. In 2001, and I start with an anecdote. In 2001, Colonel Muammar Gaddafi, during a visit to Uganda, publicly declared that leaders who come to power through a revolution should be exempt from presidential term limits. This advice seemed to find its way into the ACDEC negotiations, sparking significant debates around presidential term limits and sovereignty. Colonel Gaddafi took this proposal that he made in Uganda further by formally submitting an agenda item for the AU summit in 2006 on abolition of presidential term limits. If this proposal had been placed on the agenda of the summit, is quite likely that it would have passed, abolishing presidential term limits. The then African Union Commission chairperson, President Omar Konare, flew to Libya and succeeded in having the proposal withdrawn. This anecdote sheds light on one of the most contentious issues in the negotiation of the ACDEC and highlights the tension between national sovereignty and commitments to democratic principles. Now, all we know, there were 16 meetings over a period of 4 years. However, the actual meetings spanned, however, the 16 meetings, sorry, there were, all we know, 16 meetings over a period of 4 years from 2004. These meetings were at different levels. Being a political process, the sectoral ministers were those responsible for foreign affairs. And when politics gets in the way, things get very, very complicated. Now, let me go to issue number one, representative and democratic elected governments. An early draft proposed that a government's legitimacy stemmed from regular, free, and fair elections. However, some states objected, arguing that the representative nature of a government could apply to both democratic and non-democratic regimes. This led to a compromise in the wording to emphasize promoting an inclusive representative government rather than strictly defining it by electoral processes and linking it to representativity. Now, democratic change of government. The concept of democratic change of government led to debates about whether a change in government automatically meant democracy. Other states also expressed concerns about political pluralism. In draft Article 2.6, that was in draft Article 2.6. And the states were arguing that there was no evidence that democracy could only be assured through political pluralism. Other states argued that political stability could be achieved through non-democratic means. In the end, the articles were adopted as is. On draft Article 10.2 on referendum, this article proposed that a referendum should be a key tool for amending constitutions. However, some states felt that this was overly prescriptive. The final wording was modified to ensure that the process of amendment or revision of their constitution reposes on national consensus obtained, if need be, through a referendum. On electoral bodies, several states raised concern about the feasibility of creating independent and impartial electoral bodies, especially in countries where electoral commissions are controlled by the executive branch. The final version of the article addressed the need for independent bodies, but acknowledged the challenges some states face. Furthermore, in paragraph 3, the scope of fair and equitable access by contesting parties and candidates to the private and state-controlled media during elections was changed to reflect state-controlled media only and removing mention of private controlled media. Perhaps the most controversial issue was whether to include provisions preventing governments from using constitutional amendments to extend presidential terms under any circumstances in Article 23.5. Discussions on this paragraph focus particularly on whether or not to maintain the whole paragraph and the phrase to prolong the tenure of office for the incumbent government. Some delegations were against not maintaining this phrase on the ground that such a prolongation depended on the expression of democracy by the people in accordance with the constitutional rules and procedures in force. Other delegations insisted on the need to maintain this phrase, arguing that it was essential to ensure democratic alternation and thus prevent any attempt to remain indefinitely in power through revision of constitutions and relevant legal instruments by the incumbent government, contrary to the spirit and letter of constitutional provisions. In the end, a compromise was reached to prohibit constitutional amendments that are an infringement of the Constitution. Now, let me move on to the next section, which is justiciability of ACDEC as a human rights instrument. And I would like to start by saying that all the judgments I'm going to refer to here, all the decisions of the court I'll refer to, the pleadings by the parties, interveners, amicus curiae, are all available on the African Court's website. So anyone who wants to be able to access them, you can find them They are publicly available on the African Court website. Now, while the Act contains provisions aimed at ensuring democratic governance, the quick question is whether its principles can be enforced by judicial bodies, particularly in the African Court on Human Rights. And the case of APDH versus Cote d'Ivoire of 2016, which again one can find on the website, but also in the African Court Law Reports, Volume 1 of the African Law Reports, page 2668. This judgment provided a critical lens through which we can examine this issue. The judgment was delivered on 18th November 2016. In the case background, in 2014, the Ivorian National Assembly passed a law concerning the Electoral Commission that allegedly violated the provisions of ACDES on independence of electoral bodies. A group of 29 parliamentarians challenged this law before the Constitutional Council of Cote d'Ivoire, seeking a declaration that 4 provisions of this law were unconstitutional. The petitioners argued that representation in the IEC was imbalanced, as the law empaneled a personal representative of the President of the Republic and other senior government officials in the membership of the IEC. On this basis, they alleged that the composition of IEC was unfair and violated the right to equality, as it created, in favor of the President of the Republic, an equal treatment on account of the overrepresentation of the President within the IEC. The Constitutional Council dismissed the petition and declared the provision of the impounded law to be in conformity with the Constitution. Subsequently, the APDH, an NGO recognized by the African Union, brought the case to the African Court. APDH alleged violation of the commitment by Cote d'Ivoire to establish an independent electoral body, as well as its commitment to protect the right to equality before the law and equal protection of the law by the law as prescribed in the African Charter, Article 10.3 of the Act and 17 of ACDEC, Article 3 of the ECOWAS Democracy Protocol, Article 7 of the Universal Declaration of Human Rights, and Article 26 of the International Covenant on Civil and Political Rights, which I refer to as the ICCPR after this. In the judgment of the court, in respect of the material jurisdiction of the court had to consider whether the ACDEC and the ECOWAS Democracy Protocol were human rights instruments in order to establish its material jurisdiction. In the court's opinion, in determining whether a convention is a human rights instrument, it is necessary to refer in particular to the purposes of such a convention, reflected either by an express enunciation of the subjective rights of individuals or groups of individuals, or by a prescription mandatory on state parties for the consequent enjoyment of the state rights. The court concluded that the ACDEC and the ECOWAS Democracy Protocol are human rights instruments mainly for 3 reasons. I'm summarizing, it's a very long judgment, just summarizing. The first reason, both instruments contain provisions that directly protect the political rights of citizens, including the right to participate in elections and to equal protection before the law. Second, the court established a nexus between specific rights in the African Charter and relevant provisions in the ACDEC and in the ECOWAS Democracy Protocol in relation to the rights the applicant alleged had been violated, including the right to participation and to equal protection before the law. The court considered that even if the rights were not well elaborated, these instruments provided the mechanisms to realize the enjoyment of rights and freedom enshrined in other instruments, notably the African Charter and the ICCPR. The court also examined other aspects of jurisdiction and concluded that it had personal, temporal, and territorial jurisdiction. On admissibility, after due consideration of the 7 admissibility conditions set out in the African Charter and the court declared the application admissible. Now, on the merits, the court found 2 violations. The court held that an electoral body is independent when it has administrative and financial autonomy and offers sufficient guarantees of its members' independence and impartiality. The court observed that the issue at hand was to establish whether IEC's composition was balanced. On this point, it noted that although the domestic law in Cote d'Ivoire provided that the IEC was an independent administrative authority endowed with legal personality and financial autonomy, institutional independence is not enough to guarantee transparent, free, and fair elections as envisaged in the ACDEC and the ECOWAS Democracy Protocol. The electoral body should accordingly be legally constituted in a way that guarantees independence and impartiality and should be perceived as such. The court noted that the IEC did not have a balanced composition, with the government of the respondent state holding 8 seats, the government holding 8 seats, and other political groups and civil society holding just 4. This imbalance was reinforced by the IEC's voting structure with decision made by a simple majority. The court also noted that this imbalance was also highlighted in the October 2015 report of the African Union Elections Observer Mission on the 2015 elections in Cote d'Ivoire, which noted that there is an imbalance in the numerical representation of the ruling coalition and the political parties, and that the electoral authority does not command consensus within the political class, although the current IEC is the outcome of negotiations between the ruling party and the opposition parties, despite its heavy political component, end of quote. The court consequently held that the respondent state violated its commitment to establish an independent and impartial electoral body as provided in Article 17 of the ACDEC, and further held that the violation of this article affects the right of every Ivorian citizen to participate freely in the conduct of public affairs of his country as guaranteed by Article 13 of the Human Rights Charter. On the second violation, the court noted violation of the right to equality before the law and equal protection by the law. The court noted that these two rights are fundamental principles of international human rights law. The court found that the composition of the IEC gave the incumbent president an advantage by creating an imbalanced electoral body, which undermined the fairness of the electoral process in violation of the right to equality, equal protection under the law, as enshrined in ACTEC, the Human Rights Charter, and the ICCPR. The court therefore held that the respondent state has violated its obligation to protect the right to equal protection of the law, and so on and so on. On the orders of the court ordered the respondent state to amend the law on the Independent Electoral Commission, the law of June 2014 on the Independent Electoral Commission, to make it compliant with the aforementioned instrument to which it is a party. Now, there are other few judgments of the court that also deal with ECOWAS, Democracy Protocol, and the ACDEC, and I will briefly go through this. In another judgment of the court, Gohore, Emile, and others versus Cote d'Ivoire, application number 044 of 2019, in a judgment delivered on 15 July 2020. This application related to the local electoral commissions in Cote d'Ivoire. And the question was whether, although Cote d'Ivoire had implemented the judgment of the court by reconstituting the electoral commission, whether that reconstitution was sufficient in light of the judgment of the court. The court held that the respondent state had not fully complied with its obligation to create an independent and impartial electoral body as provided for under Article 17 of the ACDEC and Article 3 of the ECOWAS Democracy Protocol, with regard to the manifest imbalance of the number of chairpersons of the local electoral commissions. This is now the local electoral commission. In the case of APDH, it was the national, at the national level. Second, the respondent state has not fully complied with its obligation to ensure public trust and transparency in the management of public affairs, as well as effective citizens' participation in democratic processes as prescribed under Article 3.7, Article 3.8, and Article 13 of ACDEC. nor with its obligation to ensure that the electoral body has the confidence of all the political actors as prescribed by Article 3 of the ECOWAS Democracy Protocol. 3. Finally, the court ordered the respondent state to take the necessary measures before any election and to report within 3 months. So that phrase, before any election, is important. This reconstitution was to be done before any election. In another judgment, this time concerning Benin, XYZ versus Benin. XYZ because the court had, at the request of the applicant, granted anonymity to the applicant for his own protection. So it is XYZ versus Benin. Application 059 of 2019, delivered on 27 November 2020. The court found violations in only one allegation. There were many others, including that there were changes to the law before, contrary to the ECOWAS protocol, which says you should not amend the law 6 months before the elections, but the court found only violation in only one allegation. That the respondent state had violated the right of citizens to participate freely in the government of their country, provided for in Article 13.1 of the Charter, since the composition of the electoral body does not provide guarantees of independence and impartiality as required by Article 17.1 of ACDEC and Article 3 of the ECOWAS Democracy Protocol. The court therefore ordered the respondent state to take necessary measures to bring the composition of the electoral body into conformity with the provisions of Article 17.1 of the ACDEC and Article 3 of the ECOWAS Democracy Protocol on or before any election, and submit a report within 3 months. In another case concerning Benin, this was the matter of Sebastian Ajavon versus Benin, application number 062 of 2019, delivered on 4 December 2020. The court found that the respondent state has violated the obligation to establish independent and impartial electoral bodies provided for in Article 17.1 of the ACDEC and in Article 3 of the ECOWAS Democracy Protocol. 2, the respondent state has violated the obligation to establish no, I think I may have repeated that, sorry. The respondent state has violated the duty to guarantee the independence of its constitutional court and of the judiciary. So in other words, the court found that the duty to guarantee the independence of the constitutional court and the judiciary was violated, as provided Article 26 of the Human Rights Charter. 3, the respondent state has violated the duty to ensure a constitutional revision based on national consensus as provided under Article 10.2 of the ACDEC. There had been a constitutional revision, but it had breached the requirement of a national consensus. On reparations, the court ordered the respondent state to take all necessary measures within 3 months from the date of notification of the present judgment, and in any case before any election, to repeal 5 different sets of laws and amendments, including on the electoral code, and to comply with the principle of national consensus set forth in Article 10.2 of the ACDEC. This was my summary. The order itself is a little bit more detailed. In another matter, again concerning Benin, in the matter of Ongi Herrick versus Benin, application number 003 of 2020, in a judgment delivered on 4 December 2020, the court held, number 1, the violation, that the respondent state has violated the obligation to ensure that the procedure for amendment or revision of its constitution is based on national consensus and enshrined in Article 10.2 of the ACDEC. It ordered the respondent state to take all measures to repeal law of 11 December 1990 on the Constitution of the Republic of Benin and all subsequent laws related to the election in order to guarantee that its citizens will participate freely and directly without any political, administrative, or judicial obstacles in the forthcoming presidential election without repetition of the violations found by the court and under conditions respecting the principle of presumption of innocence. 3, it ordered the respondent state to comply with the principle of national consensus enshrined in Article 10.2 of the ACDEC for any constitutional revision. It ordered the respondent state to take, that's number 4, it ordered the respondent state to take all measures to repeal in the ministerial decree of 22 July 2019. Finally, number 5, ordered the respondent state to take all necessary measures to ensure cessation of all effects of the constitutional revision and the violations which the court has found. There are many other cases, but I don't have the time to go through all of them. But let me conclude on this section by saying the APRDH case was not the first time that the court had adjudicated on electoral matters. In a case called Mutikila, Reverend Mutikila versus Tanzania, in 2014, the court issued a judgment in that case and established that a ban on independent electoral candidates violated the right to political participation under Article 13 of the African Charter and directed the state to amend its constitution. In addition, regional courts in Africa, such as the Economic Community, the ECOWAS Court of Justice, ECOWAS Court, developed similar jurisprudence on electoral processes. For example, in a case against Burkina Faso, the ECOWAS Court decided in 2015 that an electoral law excluding candidates associated with the previously ousted regime violated the right to participate freely in elections and ordered the state to remove relevant obstacles to electoral participation. The case of APDH and Cote d'Ivoire shows that ACDEC is indeed justiciable and the African Court can intervene to protect the democratic rights of citizens in cases of electoral malpractices and governance failures. However, for ACDEC to achieve its intended impact, it will require more consistent state reporting, stronger enforcement by regional institutions, and a shift in political will to uphold democratic principles over short-term political gains. While the ACDEC provides a robust framework for promoting democracy and good governance, its practical impact lies on the willingness of states to comply and on the ability of institutions like the African Court to enforce it, and also the African Union Commission to assist states to implement the instrument. Now, I make my concluding remarks. As I said earlier, the biggest challenge on this continent is not the lack of norms, values, or standards. In fact, there's a feeling that the AU has done so many normative frameworks that perhaps we should have a moratorium on new norms and implement the ones which are there. Implementation is a very serious problem, both of decisions of the AU Commission, the AU Assembly, but also the bodies like the African Court. The compliance rate is very, very low. On the way forward, I think we should ask ourselves how Africa can recalibrate its political trajectory to achieve stable democracy and governance. How can we do that? If ACDEC had been fully implemented, or rather, would full implementation of ACDEC have mitigated the challenges that we've seen, challenges of electoral integrity? Would electoral integrity have been better protected? Would we have seen lesser coups, avoided the democratic retrogression that we see? Would we have seen greater respect for presidential term limits and a reduction in presidential power consolidation? I don't know. I think to the participants, I want to pose some questions. How do we ensure more effective national accountability mechanism? stronger enforcement, and political will to implement reforms. What role can participants play in commemorating this? In what ways can legal scholars and law students contribute to the enforcement of architect principles in Africa? What reforms should African legal framework adopt to prevent electoral fraud and improve vote credibility or elections credibility? Can civil society organizations play a significant role in reducing the number of coups in Africa? If so, how? Presently, the period 2017 to 2026, next year, is the Human and People's Rights Decade in Africa, 2017 to 2016, is due to conclude at the end of 2026. 2027 will be the 20th anniversary of adoption of Architect and the 15th anniversary of its entry into force. The African Union policy organ designated the theme of the year 2025, this year now, as the year of human rights, democracy, and governance in Africa. And the further recommended for this decision to be carried over to the forthcoming years. I understand from colleagues at the AU that the AU Commission is proposing or intends to propose that the theme for the year 2027 shall be the year of human rights, democracy, and governance in Africa. We don't know whether it will be accepted or not, but it's the 20th anniversary of the adoption of Architect and the 15th anniversary of its entry into force. If that is accepted, what role can participants play in commemorating these anniversaries to create awareness, more effective awareness, and foster compliance of the Architect principles? I close my presentation with those questions that I'm posing to the participants. Thank you.
Thank you very much, Ben, for that informative, powerful, insightful lecture, which provides a very important foundation for the lectures that will follow. The current state of democracy is disheartening, especially after the Pan-African institutions have adopted, as you said, so many instruments on soft law, so many legal instruments. And I think you raised a very important suggestion, which has come up before. And I think Judge Youssef has raised this as well. Why does the African Union continue to adopt new legal instruments when the last many instruments have not been signed, have not been entered into force? I believe the AU has a moratorium on new entities due to financial issues, etc. Perhaps there should be a moratorium. Should these things be taken into account when states want to have a high-level position to serve as president of the commission? You know, what are the incentives to encourage states to submit these reports? I will either give you an opportunity to address those questions, which I think you have, or I'll turn the floor over to Hajir. It is your choice.
Thank you so much, dear Virginia, you and your team, for deepening our knowledge about our international African instruments. And thank you, Excellency, Honorable Judge, for this wonderful presentation. We traveled with you from the context to the instrument, to the narrative, to the challenges, to the ways forward. And I totally agree with your point of view and your reflection. Maybe I need to complete your presentation with 4 general observations and comments. The first one is about our realities in Africa. As you said very well, we have the best instruments when we come to rule of law, democracy, human rights, respect. However, as you said, the number of coup d'etat and anti-constitutional changement of works is rising. And you gave the example of the recent 2 cases, Guinea-Bissau the last week and the Madagascar. And if we go through this wonderful instrument, we can find everything. There is no miracles. We just need to see, as said Virginia, to comply with our instruments. However, in our African context, we have maybe the first hypothesis is that our states have this deliberately violating their rule of law and their texts, and they are just do not allow liberty of expression parties. They even manipulate the elections. Or we have democracy of facade as a vitrine, just to have the aid from international financial organization like the FME, the World Bank, etc. And this is a pity because when even we comment on the average of the age of our leaders, I saw some statistics I Googled it, more than 65 years old, when our generation and our population are less than 20 years. We have the youngest population in the world, and we are the people who are governed us are very old, and this is a generation gap too. When we go to some examples in the world, like Kosovo, like Canada, like Greece, like Salvador, they have average of 35 to 40 ages. This is also something that we can express our interrogation mark. And maybe also you said, Honorable Judge, that the average of being at the government is more than 10 years. We even saw some presidents that are there for more than 35 years. So this is our realities, unfortunately. Now I come to the second observation. It's about the originality. And in all your presentation, you try to put the light on the originality of this text. One of the best originality is the Article 23, when you have the forms of what is anti-constitutional changement of government. So it is not only the classical way of coup d'etat, but even the paragraph 4 and 5, any refusal by an incumbent government to relinquish power to the winning party or candidate after free, fair, and regular elections. And the last case, any amendment or revision of the constitution or legal instruments, which is an infringement on the principles of democratic change of government. So we have at least 5, it's inter alia. That means that you can find even other. And maybe we can ask our questions here. Who are behind? Maybe, yes, we have our responsibility as Africans, but there is also the interference of the foreign countries and the powers in the world, the powerful countries who, under the cover of democracy and these issues, they need to put their hands on our natural resources. When we see all these non-state actors, when we see these wars by proxy in our countries, we can ask a lot of questions. What is behind? So this is also about geopolitics. It is not only about the context of politics and of law. One of the wonderful articles is the chapter 5. You said this culture of democracy, it can be the key. It can be the solution for all. If you go through the chapter 5, how to get a culture of democracy and peace in African countries, you have all the ingredients. We should just respect these different articles. However, I think we need another generation maybe to go there. Let's be optimistic, but this is a lot of work. One of the other issues that you raised is the sanctions, and maybe here I have a nuance. Yes, the sanction, the Article 30 of the Constitutive Act, the suspension, and all the Chapter 8 on the sanctions. However, what about the people? When you are sanctioning the government who did the coup d'etat or whatever, do you care about the population, the people, me and you, when the epidemics, for example, or the humanitarian catastrophes will not end because of a coup d'etat? African Union is sometimes in a very sensitive issue when we cut relations with these countries under anti-constitutional changement of government, but we put a window open for exceptional issues like these humanitarian issues, and especially in time of epidemics. Also, one of the, maybe if we can complete the issue of the sanctions, when you come to justiciability and accountability, we have a wonderful Article 4H amendment of it in the future. It didn't come into force yet. That for the Constitutive Act, the Article 4H is about the right to interfere in case of international crimes, crimes against humanity and genocide and war crimes. they need to add the fourth case that is called the threat to legitimate order. This is exactly the unconstitutional changement of government. So I think in the future, the philosophy of African Union is to add the unconstitutional changement of government as an international crime. More than that, we have our protocol of Malabo that is for the merge of the actual Court on Human and People's Rights plus the Court of Justice with the criminal division that will be in the future competent for these issues of unconstitutional changement of government. And I think all these are really very interesting things on the basis of the normativity. However, still challenges, as you said very well, are on the floor. Maybe the third comment is about the issue of an international court, constitutional court. You know, this is an emerging idea coming from my country, Tunisia. I remember after between parentheses, this Arab Spring, and it begins from my country, 2011, Tunisia, when the slogans are "game is over." All the revolution was about this democracy, the dignity of human being. 15 years after, if you ask Taximan or whatever Tunisian guy, are you satisfied with your revolution? He will say, no, we don't need democracy. We need to eat. We need to have, to have our daily life normal. We are behind. We are still behind. So sometimes, and here we have also to ask a question, is there a model of democracy that we can impose and transpose in our African countries, or it is a case by case? So in that time, there was a lot of research that was made, and we had some assistance from Portugal, Brazil on the statute of this international constitutional code, because we thought at that time that we are in a new era of internationalization of constitutional law and constitutionalization of international law. We are said that the paradigms of rule of law, democracy becomes universal, and we need that this issue become international, and at international level, especially that there is no international jurisdiction competent in these issues of human rights and democracy. However, I think we are not yet ready for that. I come to the last observation and the nuance to be done. As I said, there is no model of democracy, and that's why the interference, what is called l'ingérence démocratique, the democratic interference is not possible in our countries. This model of democracy can be inspirational. They can inspire African countries. However, it is impossible to copy-pasta a model of democracy. We have our own culture, our own system, our own thinking, our own traditions. In Carthage, it is 3,000 years ago. We have democracy in Carthage 3,000 years ago with election system and whatever, like Greece at that time. So this is also something that cannot be imposed. And that's why I think, again, like you said, we need to prepare the next generation for that as lawyers, as international organizations, as African Union, as professors, as lawyers, as leaders, because these people who are there online with us, more than 500, are the leaders of tomorrow. If they think about it and believe in it, they will see that development and richness and all what you want, education, whatever, will come after having a peaceful society. And this needs that we respect, and we have this initiative of respecting rule of law and our instruments, and one of them is this one. Maybe also I can put some nuance. These people who are telling us you have to do democracy ABC, let's think, they have to think twice about their system. You see this genocides of Al-Fashar, of Gaza, whatever, we didn't see any one of them saying about human rights of people that are, les crises oubliées, that we don't have any idea about. There is no interest, no power that is there, so there is no urgency. So these democracies, who are called democracies, and you can see the rise of the parties of extremism of the right in Europe and others, that are having discourse of racism daily on the internet, on the social media, in the news, whatever. So these people who are asking us to do democracy and who interfere in our systems to do democracy, maybe they have to ask themselves first what they do with democracy and the human rights. You remember even the Trump's response to Biden at that time, 4 years ago, when he didn't win the case of the election, and he pushed people in White House and in Congress and all these issues. So these countries who are saying that are leading democracy, maybe I think again that we have responsibility as African countries. Yes, we are not having good governance in our countries. However, there is this issue also of interference that maybe it is not law, but these are contexts and realities. I will be optimistic at the final observation to say that we have shared the responsibility to reflect our context in Africa. We need to consolidate our era of rule of law, and this comes from us as civil society, as I said, as academics, but also through the governments, that they need to do model laws so that they can transpire our key instruments at the national level, and even they have to see again their constitutions, because this is the Bible in any context of legal context in our countries. And to do that, I think we just need to open our eyes on what was done. The court, you are one of the judges of the court, and you did very interesting jurisprudence on the issues of rule of law during more than 20 years. You will celebrate your anniversary the next year. This jurisprudence, even if it is online in all EU languages, I'm not sure if our young lawyers are aware about it. So I think, thank you for I saw that there are links on articles. We need to see more doctrine and more analysis of the jurisprudence of the African court, but also with our sub-regional courts, ECOWAS and others who are dealing with a lot of innovation in the issues of rule of law. And let's be optimistic. Let's continue the fight. Thank you so much for this law seminar series that just bring to our attention the normativity and the originality of our norms, waiting for a newer generation maybe to go and deepen the practice of the rule of law in the future, or even now, if we are able to. Anyways, this is my hope, and this is my call. Thank you so much.
Hajir, thank you for those wonderful additional comments that supplement the amazing lecture by Ben. Ben, would you like to respond to any of the comments that Hajir made, or would you like to continue with the questions?
No, I think we can continue. I think Aja was very clear on the intervention she made.
Very good. The first question: in view of the succession of coups d'etats in Sahel, I wonder whether it may be necessary to question the democratic model currently applied in Africa. This model often appears to benefit a minority that remains in power indefinitely, the case of Cameroon being particularly illustrative to the detriment of the public interest.
I think we need to separate the case of the Cameroon and what is happening in the Sahel in that coup belt. I think the case of Cameroon should be looked at from the lens of electoral integrity. I think that is more the issue. And where one particular person has stayed in power, I don't know for how many years, pretty long time. I think that's a different issue from the one of the coup. I think the model that was established in Architect for dealing with an constitutional change of government is, I don't see another model that would have worked to deal with the problem of coups. Remember that we started with mercenaries assisting the overthrow of government in the Comoros. And then you had these coups, I think starting with the one in, was it Togo? Olympia, probably the time of independence. I don't see another model that can work to deal with coups. We really just have to deal with the imperfections of it because there's no perfect model. I think that first, one needs to be able to say coups are not allowed. Once you've said that, then you now deal with the other issue of what are you going to do when a government is in power, does not practice inclusion, is abusing or engaging in gross violations of human rights, and all other difficulties of governance. If there is a coup that happens in respect of that government, I think that would be a question that then would have to be addressed as to how do we deal with this issue in light of what was happening before the coup took place. And I think that question was addressed in the case of Madagascar in the past. I think there was a coup in Madagascar which was in the nature of a public uprising, not the recent one. I'm talking about the 90s. So the answer to our colleague who asked that question is, one, the issue of unconstitutional changes is going to be a standalone topic on Friday, which is being led by Judge Yusuf. So there will be more discussion on that, and I think you'll make a more comprehensive presentation on the issue of unconstitutional changes of government. In respect of Cameroon, there is definitely a problem, a governance deficit, but I think it arises more from electoral integrity than unconstitutional change of government.
Very good. Next question. In politically sensitive election cases, how should national courts interpret and apply the African Charter on democracy, elections, and governance when domestic law is silent or ambiguous about democratic standards?
Okay, very good question. Let me start by saying that when a state is party to an international treaty, it is obligated by the provisions of that treaty. There are no two ways about it. Now, what some states have done is to become parties to those instruments, but they don't domesticate it. And I think it depends on the particular country. For example, I can tell you that in the interim constitution of the Sudan, the African Charter is part and parcel of the constitution of the Sudan, because that's what the constitution of the Sudan says. So it depends on which particular country. It also depends on to what extent those principles have been incorporated in the national constitution, or whether the international treaty has been domesticated. If the international instrument has been subject of a decision by the African court, then that decision is binding on that particular country, if you are a party to the protocol establishing the African court. I've seen that there was another question about implementation of the court decisions. Maybe I can deal with it at this time. I started by saying that implementation of decisions on the continent is very, very poor. And I'm not talking about decisions of the African court alone. I'm talking about decisions even of the AU summit, the AU assembly. Heads of state are there, they adopt a decision, they go back, they don't implement it. They adopt a declaration, they don't implement it. In the case of instruments, there is need for something to be done to domesticate it. That's why, for example, some states that became party to the Rome Statute of the ICC, the National Criminal Court, adopted an enabling legislation to domesticate the Rome Statute of the ICC. So I think we need to ask ourselves in each particular case whether that has been done, has not been done, whether there's been a decision of the ECOWAS court on that particular instrument, the African court, because if it's like the International Covenant on Civil and Political Rights, There are many decisions of the ECOWAS Court which are binding on the countries in the West Africa. And there are also decisions of the African Court that are binding on the states that are parties to the protocol establishing the African Court. But if that is not the case, then it's unfortunate, unless in one way or the other, the principles, the values in that instrument are being incorporated into national law.
This is an issue that Judge Youssef has addressed on several occasions. The fact that what he refers to as the public law of Africa, including the African treaties, are not included in the constitution of many countries as part of their national law. This is something that he's quite concerned about. And he's also expressed concern that African countries are often quicker to sign and ratify the United Nations multilateral treaties than they are to sign their own African treaties, which were agreed to by African states and reflect the values of Africa. The fact that countries were willing to enact enabling legislation for the ICC and not for some of the AU treaties is perhaps somewhat troubling. I would like to ask you one more question and then perhaps discuss another topic briefly. This is about Article 23 of the Charter. The participant believes that it seems to focus on removal of a democratically elected government. For instance, if a popular revolution ousts a dictator, this action might be classified as an unconstitutional change of government. If this is the case, is it safe to conclude that the Charter was written to protect incumbent governments from illicit takeovers, even if the people are suffering from an oppressive government?
Yeah, I think that question is based on a premise which is not correct. That if it is a government that is autocratic, that is in power through an unconstitutional change of government, already under the AU framework of sanctions for unconstitutional change of government, that government would be under unconstitutional change of government. That government would already be under sanctions. And therefore, there will be no new sanctions for another government that overthrows that particular one. But if you are talking about a government that is autocratic, but there's been no unconstitutional change of government, then that is a different issue. And it's different in the sense that, and I think I tried to answer that question somewhat by saying that this model, I said first, there's no perfect model. And secondly, I said that it's very, very difficult to say that you are against unconstitutional change of governments. And then you go on to provide a rider that, however, if the government is autocratic, if the government is dictatorial, and there's an unconstitutional change of government, then it will not consider it to be an unconstitutional change of government. Because you put yourself in a situation where who is going to decide which government is autocratic, which government is dictatorial? I said in my presentation that governments operate by the maxim that if you live in a glass house, you don't throw stones. So no government is going to call another one autocratic. No government is going to call another one dictatorial. And the governments will not agree that you set up a committee of eminent personalities or independent experts who are going to be able to tell you whether you should characterize this as autocratic or dictatorial. Because one day it will be this government, next time it will be them. So that power has been left with the governments. They are the ones who are supposed to apply the rules that they have adopted. And when you have government representatives applying rules, it raises problems. It creates difficulties. Because you'll find that one of the delegates sitting in that body that will decide whether we go this way or this way is a government that is very, very close to the one that you are discussing. And you can't tell them that we know you are very close to this government, you go out of the meeting room. So there's no perfect system. And I think if a government is there have been instances where there have been an unconstitutional change of government, and most observers would say, good riddance. Really, that was not on. But it's still an unconstitutional change of government, because really, where are you going to are you going to be choosing and picking and saying, this is a good coup, this is a bad coup? It's a dilemma, and I think there's no solution to it. But I think the question is whether in these circumstances, you should have no framework at all, or you should have an imperfect one, or one which is not perfect. And I think the choice is clear, that you rather have something rather than none. And maybe Virginia, before I give you the floor, let me say something about implementation of decisions. I started by saying that implementation is a big challenge on the continent. Whether you are talking about ECOWAS decisions, African Court decisions, decision of the East African Court of Justice, it's a big problem. There was a study done at the African Court, and we found that the decisions that have been fully implemented will be like in the region of 20%. There are other decisions that have been partly implemented, and there are others that have not been implemented at all. And unfortunately, the international system operates on the basis, unlike the national court, where you can take somebody to court for contempt of court. For the international system, the whole system operates on the basis of states holding each other accountable. The system works better, for example, in certain regions. For example, within the European Union, there's a committee of ministers. Within the Council of Europe, there are a committee of ministers who are there to ensure, to look and see, did you implement that decision of the European Court of Human Rights? Did you implement this decision of the European Court of Justice? Why have you not implemented? You have to do it. Within the continent, it's a little bit more difficult. There is a committee of of ambassadors, and I think Aja could shed light on this. There's a committee of ambassadors, and also a committee at the level of ministers to whom those ambassadors will report. It's not long ago that was established, but it's touch and go. It's not perfect. The African Court submits reports sends copies of decisions to all member states, and is supposed to submit a report on member states that have failed to comply with their decisions to who? To the Executive Council of the African Union. And then the Executive Council is supposed to be able to say, we have a report before you, because there's a report at every session. There's a report before you that you have not implemented this. What have you done? That doesn't work very well. There are challenges, major challenges there.
I'm not sure, Hajir, are you still here? Would you like to comment?
No, thank you so much. I'm taking notes. No comment. Thank you so much.
Okay. Hajir, can you come on the screen with me for one moment? I want to switch topics, if I may. Okay. Hello. Welcome. Ben, stay on the screen. This is for both of you. Ben.
No, I'm still here. I'm not going.
Okay.
Virginia, we also have John with us.
Oh, we do. John
Yeah.
Caboti?
Oh,
Yes.
John, welcome.
John, come on, join us. John, did you want to make any comment on the subject, or do you want to wait until your lecture?
John was supposed to come earlier, actually, so that he can also intervene after my presentation, but I think he was held up somewhere else.
Okay.
But John, Virginia is asking whether you want to say something.
Thank you very much for that excellent presentation. That was very impressive. I think one important thing that we need to look at is the trend of the military coup in recent time, which contradict the provisions of the African Charter on democracy governance on the continent. And uh, His Excellency Ben Kioko has, excellently narrated different examples and what is currently going on. Particularly, if you listen to what His Excellency President Kagame said in recent time in one of his interviews, where he was trying to also buttress this argument of good coup and bad coup. And the explanation is on the fact that where the citizens don't see any democratic dividends, that tends to compel them to get to the streets and to support undemocratic intervention, interregnum in power. And this is a serious concern that we must look at critically. The legitimacy of governance is linked to the product of democratic governance. And this is a serious challenge where you don't see this type of things on the continent. And democratic dividend is one critical areas that we must focus on. When the citizens don't see the dividends, then they then become seriously concerned. And it is quite also interesting to note that, well, there are some countries, that are making progress in terms of democratic governance, democratic dividends on the continent, but the vast majority are not doing well in this regard. And one important thing, which also is in line with what His Excellency Ben Kioko has also indicated, normative frameworks, either on good governance, democracy, is a means to an end and not an end in itself. And what we are currently seeing is that we have so many numerous normative instruments on the continent, but implementation remains at a zero level. And this is a big challenge. And well, I don't think I will say much in this regard. The need for Africa to begin to look for more solutions. I'm not an advocate of conditionalities by international partners and also individuals where the African Union member state can access loan. But I'm beginning to look at an other angle to the work that we do, where the international financial institutions like the World Bank, International Monetary Fund, IMF, begin to use our own instruments as a conditionality for us before we can access loans and some grants. I think these are some of the practical way of looking at some of these issues that we are talking about. If not, experiences has proven, I think I've been in African Union now for more than a decade, and I think what we need is practical solutions to some of these challenges. Having a normative framework is not just enough. Having multiplication of institutions in place are not enough. We must come up with constructive ideas on how to influence the implementations of the provisions in our various instruments. I think I just want to conclude in this regard by saying that excellent presentation, but much more than that is that we must come up with practical strategies on how to enforce numeric instruments that we currently have on the continent that are not working. And also the issue of leadership quality and commitment is another factor. We can have good instruments in place. Democratic theories and governance theories has argued that yes, we need strong institutions in place, but experiences on the continent has also demonstrated that much more than institution, we also need leadership commitment to these democratic values. And so these are some of the things that we need to combine for us to be able to push for effective democratic governance on the continent. I think I will just stop at this end until Wednesday, when I'll be making my own presentation on preventing and combating corruption. Thank you.
John, it's a pleasure to meet you. Thank you for that comment. I think you raised an interesting point, if I understood you correctly. When the international institutions think about conditionalities for funding, they should look to the African standards, because there are excellent standards in Africa. And this would highlight and bring, for example, this important charter to people's attention. Ben, Hajir, John, you know that I'm happy to organize a seminar to celebrate the anniversary of the charter, and I'm happy to work with you at some point. Perhaps we need to have something about promoting the culture of democracy in Africa or practical solutions. So we can follow up on that. With your permission, I would like to switch to another topic that is very important to all of us, I believe, and that is ending violence against women and girls in Africa. We will be having a special event next Wednesday, December 10th, which is International Human Rights Day. It marks the end of the UN 16-day campaign to end violence against women and girls. After Hajir's amazing lecture on this important new convention, participants started this grassroots movement, which has now grown to, I believe, about 3,000 participants or more. And we have a petition which has been signed by more than 3,000 people. Participants in the coalition include all 55 AU member states. Signatures on the petition represent all 55 AU member states. And I would like to take this opportunity to thank Hajir for being the very first person to sign the convention in her personal capacity. And I would also like to thank Ben for his guidance and for being the second person to sign the petition. Hajir will be joining us on Wednesday during the special presentation, and she will be able to answer many of the questions that coalition members have asked me. It's important to have this discussion. I know there is a counter petition to put a pause on the ratification process to fix the convention. My own understanding, based on Hajir's lecture that we can follow up on next week, is that people worked very hard, and this was the most that the sovereign states were prepared to accept. And if someone could assure me that this convention could be fixed and significantly improved within a year, okay. But how many more years can we expect the women and girls of Africa to wait to have a better future? So I will be pushing very hard for this next Wednesday. And John, I'll send you a copy of the petition so you can sign it and join us. Ben, is there anything you'd like to say? Why is it important? This convention is not perfect. No convention is perfect. Why is it important to have an African Union Convention specifically addressing the widespread, very sad problem of violence against women and girls in Africa? Any words of inspiration for the participants to join this fight?
I think taking into consideration, particularly in the war zones, like what is currently happening in Sudan and in some of our member states where we continue to witness terrible, unimaginable violations against the women, there is no any other explanation that can contradict why we don't need this type of instrument at this particular moment. And one thing that I would just want to say is that while thinking about this type of instrument, we should also think ahead in time of strategies on how to bring about effective implementation of this type of instrument. Thank you.
The news media does not always cover Africa extensively, but I have read the heartbreaking stories of the extensive rape of women and girls in that war, which is really heartbreaking. Ben, any words to encourage the group to join the fight to end violence against women and girls in Africa?
I'll be
Definitely.
with you on Wednesday.
On Wednesday, okay.
Yeah, I'll be there.
Oh, wonderful. Okay, great. Thank you all of us for joining us today. It was very educational for me, very enlightening. I have to say, a bit disheartening that there are so many wonderful instruments, and the reality is something quite different. This is something that we'll continue the discussion.